Under the Companies Act, not all companies are the same. For instance, we have private companies, public companies, Section 8 companies. We also have small companies, government companies, foreign companies, and so on. So in this video, we'll make an attempt to explain each of this type of company and what are its characterizations. Let's start with private companies. See, private companies are those where the shareholding is closely held. You take any startup, be it Flipkart, Amazon, Google, or any of the startup, initially their initial phase of business will be a private limited company because that is usually suitable for a small business to take off, right? So a private limited company is a company which is closely held. The shares are closely held. Share transfers are restricted, right? And you need minimum two members, that is two shareholders and two directors. So this is about a private limited company. A public limited company is one where there is no restriction on transfer of shares and there is no restriction on the number of shareholders, and you should have a minimum of 7 shareholders in your company, and these are usually those companies for which when you are looking for going into the phase of more funding, right? Because in public company there is no restriction on number of shareholders nor on the share transfer. So therefore, it is a good vehicle when you're looking for more investments to come in, or also when you're looking for making it a listed entity at a later time. So, for instance, Eternal, that is Zomato or Swiggy, they have converted themselves into public limited companies before getting listed. Right? So that's the relevance of a public limited company. As we move forward, let's look into other type of company, which is OPC, one person company. Now, what is a one person company? A one person company is a company where there is only one shareholder, a sole shareholder, right? So this is a clear fit for a sole proprietorship business. If you're looking for giving a separate legal identity for a sole proprietor business, then you can convert that business into a one person company, right? So this is a new concept introduced under the Companies Act 2013. As we move forward, small company. Small company comes under the classification of private limited company. So the broad classification is private limited. Under private limited company, one sub classification is a small company. So this is a private limited company where the paid up capital is less than or equal to 4 crores and the turnover is less than or equal to 40 crores. So technically, you should not have a paid up capital exceeding in excess of 4 crores, or nor should you have a turnover in excess of 40 crores. That's when you are classified as a small company. Is there any benefit for you to be a small company? Oh yes, there are good amount of exemptions, relaxations, and also certain different provisions provided for a small company with relaxed statutory requirements whenever you are a small company, right? Let's move ahead. Section 8 companies. See, Section 8 companies are those which are non-profit companies. That is, the objective of these companies is not for profit, right? So these are not-for-profit organizations, NPOs, and these are also those companies which have a charitable objective. So the objective of these companies is charitable, any charitable object, right? So these are the companies which are incorporated under Section 8 of the Companies Act 2013. In the erstwhile Companies Act, that is under 1956, these are under Section 25. They were termed as Section 25 companies. Now they are Section 8 companies. Now, recently, many of the NGOs are converting themselves into Section 8 companies because the regulatory path, what we see, even for CSR activities or for listing before the stock exchanges in the social stock exchange and all, Section 8 companies play a very crucial role because of the transparency and also because of the fact that they are regulated, they have regulatory guidance and regulatory requirements in place. So thereby, anyone who is funding into a Section 8 company can know very clearly, and there are transparent measures to understand their accounts and that the accounts are getting audited and all. While you give fund to an NGO, unless they voluntarily disclose something, you will never have any information of whether the fund is going to the right use or not. Whereas in a Section 8 company, you have an auditor who is appointed to provide audited financial statements, and as part of the audited financial statements, you can know where this fund is put to use and what is the income expense position of this particular fund. So Section 8 companies have this relevance. So these are not-for-profit companies with an objective of charitable in nature, right? So next we'll move ahead with government companies. See, government company, again, it is not like a separate set of company. It is either a private company or a public company. So the broad aspect of private and public company will remain the same. Under this company, be it a private or a public, if the government, be it a central government or a state government, owns more than 50% of the shares, more than 51% of the shares in this company, then it will be considered as a government company, right? So government company is one where it has more than 51% shareholding in the private limited or public limited company. And just as a quick fact, and rather an interesting fact, if it's the central government which is holding shares in a company, then the owner of the shares, that is the shareholder or the member of the shares, will be the president of India. If the state government owns shares, then it will be the governor of the state, right? So the ownership of a central government asset always lies with the president of India. Of a state government investment always lies with the governor of the respective state. It's just for your interesting. I just thought it's an interesting fact to share. As we move forward, the other type of company is a foreign company. Now, see, a foreign company is one which is incorporated outside India. That's the reason why we call it foreign. But it has a place of business in India, right? So, a business which is a company which is incorporated outside India, having a place of business in India is considered a foreign company. So, which technically means if a company is incorporated in India as a subsidiary or whatever, you cannot treat this company as a foreign company just because all its shareholders are foreigners or all its directors are foreigners. It doesn't make a company a foreign company. Its place of business, its place of birth, right? I mean, the place where the company is incorporated should have been outside India. That is when it will be termed as a foreign company, right? Like you can say Amazon, Google, or Microsoft. Their parent companies are all foreign companies to India. They have place of business in India, right? So let's say they have their corporate offices in India. They have employees who are working from India. So in such a situation, they will be termed as a foreign company, right? As we move forward, the last one, we will let us understand one relationship of between these companies: holding, subsidiary, and associate. Who is a holding company, who is a subsidiary, and who is an associate? See, holding subsidiary is a relationship amongst each other. Where a company holds more than 50% shareholding in another entity, then the one which holds 50% is termed as a holding company. The one in which the other company is holding 51% will be termed as a subsidiary. So you will become a subsidiary company of a holding company when the holding company holds more than 51% share or 50% shareholding in your company, right? So this holding subsidiary relationship becomes more important even from the accounts point of view, considering the requirement to prepare consolidated financial statements where you have a holding and subsidiary. And it also becomes relevant in terms of certain statutory relaxations between the transactions. The transactions between holding and subsidiary companies, there are certain statutory benefits being provided. And there's also this concept of wholly owned subsidiary. This is a situation where a holding company holds more than, rather holds the entire shareholding in the subsidiary, with nominee shares being allotted to the other shareholders just to meet the minimum number of shareholders. That's when this relationship will be wholly owned subsidiary, right? So a holding company and a subsidiary are a relationship between each other, right? So this is something which is relevant under the Companies Act 2013. And further, there is also another concept of associate companies. Typically, associate companies are those where you have a holding of more than 20%. So where a corporate holds more than 20% shares in another entity, these two entities become associate companies, right? So associate companies also have a relevance when it comes to preparation of consolidated financial statements. And all this relationship of who are our holding companies, whether you have subsidiary companies, and what are the associate companies of your company, etc., shall be disclosed in your board's report, right? So that's why this becomes more relevant for any company. I hope you found this video helpful. So this video is meant to provide for a brief idea of how these companies are and what these companies are all about, right? Hope you like this video. If you do so, please do leave a comment and like our video, and please do follow VirtuaLaw. Thank you.